Good morning, everyone. Today we will begin our discussion of computer laws at the federal level. And what I thought I'd start with is a quote that I found while reading the book that I mentioned in one of the prior classes, this book entitled The Internet Police by Nate Anderson. And there's just one quote that caught my eye. It said, as the internet filled with people filled the internet with everything that was worst and best about humanity. And I think that's pretty well spot on. As a interconnected web of intellectual property and collaborative endeavors, the internet has become a place of great sharing, but as we learned in just some of the past classes, that some of that sharing is for nefarious purposes. And thus the need for laws. So first we will be talking about some laws that have emerged at the federal level, some of which have been around and on the books for quite some time. Some are, a little bit newer, but as you'll come to appreciate, really a law is never entirely cast in stone. That there's some maturity that has to exist in the legal realm where a law is put up for review and freshening. And as accurate and precise and thorough as the writers of laws sometimes try to be, something always seems to slip through the cracks, and thus the need to re-look back and really ask questions about the wording of the law, the thoroughness, the weasel room that might exist, and the need to make some changes. So in this class, we'll talk about 8 or 9 laws that are at the United States federal level. You can see there's the Ribicoff bill. That was a proposed bill that didn't actually pass into law. We'll talk a little bit more about that. We have the Computer Fraud and Abuse Act of 1986, really the first and most fundamental of computer crime laws. Also in 86, the Electronic Communications Privacy Act. The Communications Decency Act appeared in 1996, a decade later. It was the first legislative attempt to curtail internet pornography. In 97, we got the NET Act, an acronym for the No Electronic Theft Act. The DMCA, or Digital Millennium Copyright Act, was signed into law in October of 98. We've got CIPA or CIPA, the Children's Internet Protection Act, which was signed into law at the very end of the year 2000. CAN-SPAM Act of 03 was a somewhat pivotal because it was the first law that governed the transmission of commercial email. And then in 2008, the Identity Theft Enforcement and Restitution Act. We'll dig a little deeper into all of these. And in fact, you're going to be pursuing a project where you choose one of these federal laws, or if you dig deeper and find yet another federal law that piques your interest, and you will really do a deep dive into the law and cover some of the nuances in the verbiage, find a case in which the law was used in the prosecution, and you'll develop your own presentation, which I'll talk about a little later in the class period. So let's begin here with the Ribicoff bill. The Ribicoff bill again was proposed and never did pass into law. It was proposed by Senator Ribicoff, and thus the name, and it was trying to make a case that prosecutors were having to shoehorn their cases into some other existing law. And Senator Ribicoff was proposing that it was appropriate to create a new statute specifically relating to computer abuses. And at the time, the bill was being referred to as the Federal Computer Systems Protection Act of 1977. And while the bill did not pass into law at that time, it really put Congress and other players, business people, etc., it put them on a footing for future computer-related legislation, and really was a run-up to this law, the Computer Fraud and Abuse Act of 1986, which is known as the first and most fundamental of computer crime laws. This law was aimed specifically at protecting computer systems that came within the federal purview. So the law made unauthorized access of certain information explicitly a criminal act. So anything national security related, all financial records, information from a consumer reporting agency, and information from any department or agency of the United States government. So in short, this law makes it a crime to even access a federal government computer, even if the perpetrator didn't take any information, or even if there was no intention of harm. There are reasons why it is characterized in this way. Let's just talk through a couple of those. One, when a person intrudes on a system, harm might happen even if there was not intent for it. Secondly, just like in the physical world, we have breaking and entering, and that's a crime. So in the digital world, when a perpetrator is caught before the crime or theft is complete, it's necessary to have a law which confers guilt regardless of further action that may or may not have occurred. So the Computer Fraud and Abuse Act, sometimes written as CFAA, also makes it a crime to traffic in information, such as peddling passwords or selling other account access knowledge on the dark web. There's also broad language in the act that makes any threat to public health or safety a crime. So you can see that this is a very overarching law. The Electronic Communications Privacy Act of 1986 is a critical piece of legislation with regard to computer crimes. In fact, it specifically addresses those crimes in the digital realm. This law covers how evidence can be gathered. It extends federal wiretap laws into the domain of these newer electronic communications medias. There was some controversy pertaining to this law in its earliest inception. Some questions were asked. Was an email copy stored on an email server considered as private as the content on one's own computer? Early on, a court ruled that an email found on an email server was not protected under privacy law. However, in 2005, the United States Court of Appeals for the First Circuit reversed that opinion. An end user, typically a novice in the computer world, would have the expectation of privacy in an email correspondence. And this is what the appellate court upheld. So what this means is that an email on an email server is considered to be a private communication, just like a phone call would be. Law enforcement officers are then under a burden to seek a warrant for accessing any of the data. Oh, yes, as a little extra on that one, you may want to study a case, the United States versus Councilman, Councilman. That case occurred prior to the year 2005. And had some impact on the Electronic Communications Privacy Act that went into effect in '86. Okay, so now we're moving ahead almost an entire decade to the Communications Decency Act of 1996, the first legislative attempt to curtail internet pornography, specifically to reduce children's access to this illicit material. The act was actually part of Title V of the Telecommunications Act of 1996. And it was, again, specifically meant to reduce access to pornographic material to anyone under the age of 18. Large portions of the act were struck down because they were overly broad in their language. This is a common problem with language and law. It is so important to be crystal clear when writing any kind of specification, whether you're writing a specification for a computer program or writing a specification for a statute. The instructions have to be taken in a 100% clear manner. The Supreme Court ruled that the indecency provisions in this act were an unconstitutional abridgment of the First Amendment right to free speech because they did not permit parents to decide for themselves what material was acceptable for their own children. The Supreme Court also opined that the Communications Decency Act were overly broad in their phrasing of, quote, patently offensive, end quote. They indicated that that was not clear language and had no prior legal meaning. So what could be patently offensive to one may not be so to another. In 2003, Congress amended the CDA, the Communications Decency Act, and removed that indecency provision. And that amended act is the current federal law. Important wording to note in the act, and I'll quote it here because that's the best way to deliver the information to you. It says, quote, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider, end quote. Basically, what that means is that ISPs and web hosting companies cannot be liable for the content that customers or consumers of their product and service may post. And you know that the Communications Decency Act has come up in recent conversations, in recent current events regarding the latitude that a service provider may or may not be obliged to in terms of the publishing of misinformation. So that is a whole entire debate in itself. The No Electronic Theft Act, or sometimes called NET 97, is based off of House Resolution 2265, signed into law by President Bill Clinton on December 16th of 1997. It's a law that provides law enforcement and prosecutors the tools to fight copyright violations on the internet. The law makes it a crime, and this is an underlined text on the screen so you can read it with me, makes it a crime to reproduce, distribute, or share copies of electronic copyrighted works. It's a crime even when no financial gain is at stake. The law requires that the distribution is willful and that the retail value of the copyrighted material exceeds $1,000. There's a 5-year statute of limitations, meaning the crime must be charged and prosecuted within 5 years of the commission of the reproduction, distribution, and sharing of the copies. Other aspects of the law include making it criminal to remove a copyright notice from a copyrighted electronic product, and making it criminal to place a false copyright. In other words, to claim copyright on an already copyrighted work under another name. This law also applies to copyrights on live musical or theatrical performances. And this means it's a federal crime to record live performances without the expressed written consent of the venue and the author of the production. The Digital Millennium Copyright Act, DMCA, signed into law in October of 1998, makes it illegal to attempt to end run copyright protection technologies, such as using any measures that are used by manufacturers of DVDs, compact discs, etc., that would prevent the copying of the material. Since fewer and fewer things are being distributed in this method, we're not seeing as much of illicit duplicating of DVDs, etc. But it does apply to the intercepting of bits and bytes that would be streamed for software downloads or musical performances, etc. The DMCA does have a safe harbor provision, again, for service providers and content hosts that would protect them from prosecution if their service is somehow hacked by one of their customers to violate the DMCA. So the big takeaway of the DMCA is making it a crime to attempt to circumvent copyright protection technologies. Now let's talk a little bit about CIPA, the Children's Internet Protection Act, which was signed into law in December of the year 2000 and makes it a requirement for libraries and schools to filter content to any device accessible by children. Adult patrons of the library can request that the filtering be disabled for their use. And so what's the hook, you might say? Well, schools and libraries that are subject to CIPA law may not receive discounts offered by the E-rate program unless they certify that there is in fact an internet safety policy in place, including technology protection measures. Schools must also certify that they are educating children about proper internet hygiene, proper netiquette, polite behavior, anti-bullying instruction. And they must restrict minors' access to harmful materials. So up for discussion is, well, what material is harmful to minors? That also can be in the eye of the beholder. I urge you to look further at the verbiage of the law, which you can find by internet search. And look specifically at Section 2, Part C of the law. Perhaps one of you will want to inspect this law for your project. The law again, requires libraries to turn off the filter if proof can be made that a person is over the age of 18 and puts in a request for such. The Can-Spam Act of 2003 interesting law, pivotal, because it was the first law concerning the transmission of commercial email. Many feel that the law has too many loopholes in it. In fact, unsolicited email is not prohibited by this law. The only requirement to comply is that the sender must provide a method whereby the receiver can opt out. And that method of opting out must not incur any charges. Mass mailings that have no commercial component to them are not covered by the law. A couple examples. On February 16th of 2004, Anthony Greco, who was 18 years old at the time, of New York, turned out to be the first person to be arrested under the Can-Spam Act of 2003. And Mr. Greco indeed pleaded guilty. It's not known even now what the final plea or disposition of the case turned out to be. A little later that same year, in September, a gentleman named Nicholas Tombros put in a guilty plea and became the first person to be not just arrested, but convicted under the Can-Spam Act of 2003. Mr. Tombros was sentenced 3 years later in July, given 3 years of probation, 6 months house arrest, and a $10,000 fine. So again, there's many other convictions under this act. You may want to research one of those. The Identity Theft Enforcement and Restitution Act of 2008. That is a mouthful. This act eliminated a requirement that was in the Computer Fraud and Abuse Act for there to be a $5,000 in damages threshold in order for the offense to be prosecutable. Also, this act made threatening to damage a computer system or to steal data from it a felony. It made any hacking of a system also a felonious offense. This legislation expanded identity theft laws to organizations. So prior to this, only natural persons could legally be considered victims of identity theft. Under the Act, organizations could also legally be considered victims. This law also makes it a crime to conspire to commit fraud. Starting in 1984, the United States federal government began enacting laws aimed at cracking down on computer-based crimes. And while not all crimes will be investigated or even prosecuted under federal jurisdiction, many still will. So a fundamental understanding of these key piece parts in the federal mosaic will help give you a framework for understanding all computer crime laws, all technology crime laws, whether they be at the federal, state, or local level. So let me draw your attention back to the Moodle page, where you will be able to find the PowerPoint slide deck upon which this discussion was based. Also, I have put links to some general packaging of information on each of these laws, and even some additional ones. One that you will find interesting, I'm sure, is the RICO law. We hear a lot about RICO racketeering when we consider organized crime. And we know from one of our recent discussions about the blue box and the circumventing of the phone system by organized crime to make some free phone calls and also to obscure their identity information, that sort of digital crime or crime in the digital realm and organized crime, seem to march in lockstep. So RICO was a law designed to combat organized crime in the United States, and it's often applied in both physical crime and digital crime cases. So you will see a lot of different URLs or web addresses for these various laws. But let me draw your attention down further yet to an assignment that will be due at the end of the week, Sunday. And that is an analysis and reflection on the examination of child pornography. And it happens to be based on the PDF that you see in the center. And the worksheet is separate from the assignment submission link. So look for it here. It's analysis questions. Even more importantly, let's slide down just a little further and we'll see a project rubric and a project submission link. This is due in 2 weeks. So you can see we're at the 14th. The coming Sunday is the 20th, so yet another entire week. We have February 27th for a presentation on the US computer laws in as a project grade. So it's going to be a unit grade like an exam for you. And what you must do is choose a federal law that applies to digital crime, specifically one of the ones I talked about today, or RICO, or another that you find through research. And you're going to develop a 7 to 10 minute presentation. So not as long as I spoke to you today, something, not something brief. Your face does need to appear in at least a minute at the beginning and a minute toward the end, or it can appear all throughout the presentation. If you use Zoom to create your recording, you can have your webcam image as an inset on the screen. Also, there's plenty of other free trial versions of screencasting software that you can use to create a short video. There's Camtasia, Screencast-O-Matic. I'm sure you can find others as well. You'll use PowerPoint or really any slide deck application of your choice as a backdrop for your discussion. Make sure you don't read your slides in your presentation. Bad form, okay? So really you just want the slides as a backdrop. And you can see the basic criteria upon which your presentation will be gauged, scored. So if you have any questions, do make sure and contact me by either email or have a Zoom meetup. If you have any questions about using technology, you can ask me, or you can contact the distance learning people at ACC. It's just a requirement through all courses that you occasionally have to present. So that will be the unit assessment for this unit. On Wednesday, we will talk a little bit more about federal prosecutions, the kinds of things that need to be prepared if taking something to trial in the federal arena. And we'll also discuss child exploitation and trafficking and some of the other big ugly crimes that are prosecuted under these federal umbrellas. So anybody have any questions about assignments or any of the topics that we discussed today? All right. In any kind of online course, even a synchronous one like this, there is a requirement occasionally through the semester to identify who you are, like I'm doing. You can see my face right now. So that's part of the requirement for this project as well, is for you to show your identity and we can know you better. So make sure that is in your project. All right, I will see everyone on the next class meeting. That's all.